Finally, to test data protection, Article 39.3 requires that members, as a condition of protecting or of approving marketing of pharmaceutical or agricultural chemical products which involve new chemical entities, they shall protect the data against unfair commercial use. Now, this requirement has bearing in the principles of unfair competition, as mentioned in Article 10 bis of the Paris Convention, wherein if there are certain practices that are contrary to honest commercial trade practices, such practices shall be avoided or regulated through the law of unfair competition. Article 39 specifically requires the WTO members shall protect confidential information by way of some form of protection against misappropriation of such information. Furthermore, Article 39.3 specifically lays down the standard for unfair commercial use of test and other regulatory data. However, what this unfair commercial use means has not been clearly defined. Some countries say that this creates an obligation for data exclusivity. However, no WTO dispute settlement panel has ever ruled on this issue. India, for example, follows the principle of permissive reliance, wherein a subsequent generic approval may be granted by the Drugs Controller General or the Federal Drug Regulatory Authority by relying on the data submitted by the originator, and this shall be considered as permissive reliance. Furthermore, in the Indian context, India is very unique in the pharmaceutical arena because India's pharmaceutical policy has consistently tried to demonstrate its concerns for global access to medicines and also its economic interest involved in generating and nourishing a strong generic industry. It is also called as the pharmacy of the world in the sense that India is one of the largest exporters of generic pharmaceutical products in the world. It is 4th in terms of volume and 13th in terms of value. It is also important to note, considering that there is a background of pharmaceutical industry and India's concerns for access to medicines, India led the Uruguay round by specifically requesting other negotiating partners to agree on compulsory licenses. Specifically, Article 31 was negotiated by India along with the support of other WTO member countries. So, India has subsequently sought implementation of the TRIPS agreement in a phased manner. So, India required to implement all the provisions of the TRIPS agreement in a 5 years duration because it was a developing country in transition. Specifically, in the case of product patents for pharmaceuticals and agrochemicals, India was granted a 10-year transition period. Of course, it was at the option of countries whether to have the transition period or not. For example, Brazil is one country which did not opt for a transition period and it straight away went on implementing the requirements of the TRIPS agreement. But since India sought a transition period, the product patent regime for pharmaceuticals kicked off only in the year 2005. So, the 2005 amendment to the Indian patent law is kind of critical in understanding how India is trying to manage its access regime for pharmaceuticals. It is important to note that because of such kind of unique provisions, Indian law has been constantly criticized and evaluated by other comparative jurisdictions, primarily by the United States, in terms of its annual report called as the Section 301 Priority Watch List, and India has been in the Priority Watch List even in 2014. However, we have not been declared as a priority foreign country. If you are declared as a priority foreign country, US has within the law mechanisms to take unilateral action. The consistency of such action at the WTO is questionable because prior to this, because the European Commission, European communities had challenged this law in the late 1990s, stating that this particular law and unilateral action involving the US section 301 to section 310 are in violation of article 23 of the dispute settlement mechanism. However, the WTO has come to a conclusion that they may prima facie not violate the WTO requirements. However, if US has to pursue its interest and take unilateral action against WTO member countries, then it may definitely violate the WTO agreement. India has used various flexibilities in the TRIPS agreement, primarily involving two of them. One, in terms of determining what subject matter can be excluded from patent protection in the case of pharmaceuticals, and also in terms of determining the grounds for compulsory licenses. And these two issues have been taken up for discussion because they are quite contemporary in nature. The section 3D of the Indian Patent Act, if you can look into the Patents Act of 1970, defines what inventions may not be patentable, and in section 3D, new forms of known substances or new uses may not be patentable if they do not lead to any significant demonstration of efficacy. Now, how this efficacy has to be defined and whether this includes any kind of efficacy involving clinical efficacy like those relating to advantages of the product in terms of its administration on patients, or in terms of its easiness in relation to manufacturing, and therapeutic efficacy, which means that the invention, the pharmaceutical invention, has to cure the disease in a better way. Now, this came to be challenged in the Supreme Court in India in the Novartis case, Novartis versus Union of India, decided in 2013, and Supreme Court said that section 3D requires some kind of demonstration of therapeutic efficacy, which means that apart from the fact that the invention qualifies for novelty, inventive step and utility, in India pharmaceutical inventions also need to be shown that they are therapeutically efficacious. But this does not apply to all classes of pharmaceutical invention. This applies to only new forms of known substances and those kinds of exclusions which are mentioned in section 3D. This was quite controversial in the sense that article 27.1 of the TRIPS agreement says that you shall grant patents on any invention provided they involve novelty, inventive step and industrial application. Critics are of the view that this criteria of therapeutic efficacy adds on as a fourth criteria, which is hitherto not mentioned in the article 27.1 of the TRIPS agreement. TRIPS consistency of India's pharmaceutical compulsory licenses has also been questioned in the US report, in the USTR report, as much as section 3D has been questioned. In Bio versus Union of India, the Intellectual Property Appellate Board and also subsequently the High Court in 2014, Bombay High Court, has upheld a compulsory license granted by the Patent Controller General of India, wherein one of the grounds for grant of compulsory license was based on the ground of non-local working, as in non-manufacturing the patented product in India. We will discuss a bit in detail about section 3D. Section 3D was introduced by the Indian Parliament primarily to avoid evergreening, in the sense that a phenomena which has classically not been defined in a patent law, but in generally in innovation art it would be defined in terms of patent thickets around one singular patent, which delays the entry of generic medicines. However, evergreening is not purely an Indian concern. This concern is throughout the pharmaceutical industry, primarily due to decline in productivity. The EU Pharmaceutical Sector Inquiry Report actually confirms this kind of evergreening, wherein they mention that individual medicines are protected by nearly up to 1000 patents, product specific patent families, which can lead up to 1300 patents or pending patent applications across the member states. So it means there are very high rate of number of secondary patents that are filed in relation to a new chemical entity. There is also some evidence to the fact that evergreening creates certain high entry barriers for generic drugs. So the question is whether such concerns should be resolved through competition law or patent law. India has taken the route of patent law, by virtue of which a preventive mechanism like section 3D has been introduced to prevent evergreening. So as mentioned in 2003, Supreme Court defined that although Novartis invention may be efficacious in the sense that it had beneficial flow properties, better heat stability or lower hygroscopicity, it did not simply matter, because ultimately Novartis were not able to show that due to these factors the enhanced bioavailability, which Novartis was claiming as 30% in relation to its invention, was not actually leading to improvement in the therapeutic conditions of the disease. So that particularly meant that unless you show therapeutic efficacy, you cannot grant a patent on certain pharmaceutical inventions. It is controversial in the sense that this adds to the existing criteria of inventive step, novelty and utility, while may also be subsumed in these three criteria, and also in relation to its how we define the term invention. But nothing seems to be clear at the moment whether this would actually fall foul of Article 27.1 of the TRIPS agreement. Finally, India's first compulsory license was granted on various grounds: that the price was not reasonable. Bayer was selling the drug Nexavar, which is an oncology drug, at the rate of $5,500 per patient per month, and that Bayer was, because of this price, was able to cater only 2% of the Indian patient population, and also that Bayer did not actually locally manufacture the drug, nor did it license the drug in India for local production. If you look into records, Bayer was actually importing the drug for the last few years, and since it was purely importing the drug and not taking any measures towards locally manufacturing, a compulsory license was granted on all three grounds. Primarily that the price was extremely high, that the reasonable requirements of the public in relation to the invention were not met, because only 2% of the patient population was being provided with the drug, and that the drug was not locally manufactured. The decision has been of the controller has been upheld by the IPAB and the High Court. IPAB modified some parts of the order, which included, among other things, inter alia, interpretation of the provision on local working, wherein the IPAB specifically said that one of the ways in which local manufacturing may not be complied is by exclusively importing the product. But if reasonable steps can be taken, and if the patent holder shows that he had actually taken reasonable measures to manufacture the product, then such kind of consideration can be taken, and the patent may thus not be compulsory licensed on this particular ground. In summary, the unique nature of the pharmaceutical industry and its relationship with IP protection and the role of IP protection must be considered for arriving at optimal IP law and policy in the context of pharmaceuticals. This also involves effects of patents on price based competition and price discrimination, as to how much can developing and least developed countries pay for pharmaceutical innovation and access. Thirdly, the innovation landscape is changing, primarily because we are shifting from new chemical entities to new biodrugs and also some kind of nano drugs. So hence innovation landscape is changing, the chemical entities are on decline. TRIPS provisions on pharmaceutical patents were primarily a sort of due to the lobbying efforts of the pharmaceutical companies during the Uruguay round, and that explains the use of private power in public law. TRIPS agreement and TRIPS plus agreements are on the rise, primarily by way of free trade agreements and also by virtue of bilateral investment treaties that are signed by WTO member countries. New plurilateral agreements like ACTA, the anti-counterfeiting trade agreements, and the Trans-Pacific Partnership agreements and IP chapters relating to them specifically go TRIPS plus. TRIPS is Paris plus, in the sense that the Paris Convention was insufficient in actually setting the right standards for international patent protection. However, TRIPS establishes certain minimum standards. It is not a maximum standards agreement. Hence, Article 1.1 of the TRIPS agreement allows WTO member countries to go TRIPS plus. TRIPS achieved certain key results by linking the provisions with the dispute settlement. Since the TRIPS agreement has been linked to the dispute settlement, WTO member countries are required to implement the law, and any flaw in implementation of the WTO TRIPS agreement can be litigated at the WTO dispute settlement mechanism, which also further involves certain kind of sanctions that may be imposed by virtue of the law not being compliant with the WTO requirements. The TRIPS agreement specifically requires that product patents must be provided, and very few exclusions have been allowed in case of pharmaceuticals. If you look into the negotiating documents, it clearly states that one of the concerns was that some countries like India and other developing countries were not offering product patents for pharmaceuticals and agrochemicals. So this was specifically negotiated, and hence TRIPS agreement says that you shall not make any discrimination whether in terms of products or processes, place of invention, whether the product is locally imported or whether the product is imported or locally worked, or also discrimination in terms of field of technology. Limited exceptions and compulsory license are allowed by the TRIPS agreement. This is a major flexibility that developing countries have negotiated, and hence it is important that while considering implementation part, especially in relation to India, we need to understand that TRIPS agreement allows you certain great freedoms, and India has taken a great clue in implementing those freedoms and flexibilities. Special and differential treatment for least developed countries is also provided through continuing transition period. So the transition period right now for LDCs for implementing the TRIPS agreement is 2021, provided that they comply with national treatment and most favored nation treatment. And also these countries would not be required to implement the patent pharmaceutical provisions in the TRIPS agreement till 2021. Export licenses to resolve public health issues are specifically allowed by virtue of the Doha Declaration on Public Health. Subsequently, the August 2003 decision clarifies the actual mechanism through which these particular type of export licenses may be granted by any WTO member countries to those countries where the pharmaceutical manufacturing capacity is either limited or insufficient. The Indian context is unique in terms of the fact that India has tried to utilize the flexibilities in the TRIPS agreement by way of taking preventive measures like section 3D, and also by way of allowing compulsory licenses on various grounds, including the ground of non-local working, as in non-local manufacturing. So with all of this, we can come to a conclusion that TRIPS agreement is a document that tries and balances the rights of the patent holders vis-a-vis the rights and obligations of the patent holder vis-a-vis the user's interest. At the same time, TRIPS in relation to patents requires WTO member countries to specifically implement the product patent provisions in relation to pharmaceuticals and also other inventions, and also defines rights, requirements relating to disclosure, requirements relating to the term of protection, requirements relating to limited exceptions, and also requirements relating to use without authorization involving compulsory licenses. Thus, we may conclude by saying that TRIPS is both a kind of a document that relates to the protection of IP right holders. At the same time, it has taken certain care in balancing its interest with public interest aspects of public health and access to medicines. I hope you have understood this particular module from both a conceptual and policy perspective, and the legal dynamics involving both the international protection relating to pharmaceutical patents and its implementation by taking a specific country example like India. Thank you very much.